complaints in this case. Ms. Sarah, what is it that you would like to say on your behalf here today?
Well, I still have not received any pension. It's now 5 months owed. I did receive an email from the pension company saying he finally completed the paperwork in June, which it was supposed to start in March. So I don't know where that's going. As far as his firearms, I have never had them in my possession. My son has them, and my son told me that he had talked with his father, and his father agreed that my son would hold on to them until they figured out what to do. I've never had them in my possession. So I know he keeps saying I do, but I don't know anything about guns. Why would I want them? A few were sold by my son just after I was forced out of my home. They made the car payment for a few months because I had no income, and they paid for my son's storage in California while he moved here. Also, he claims that I am late on the car payment. Well, he was supposed to pay the March and April car payment and insurance, and he never did. He still has not. I got a letter saying that, or an email saying that the car insurance is still in effect. Well, of course it is. I had to pay it, but he was supposed to pay March and April. I went without car insurance for 5 days, didn't drive the car because I had no money to pay it until I got support from him. At this time, it's over $5,000 when you count the pension, the car payments, the insurance. I don't know what to do from here. I'm at a loss.
Okay, thank you.
This case is messy. Divorce judgments are supposed to bring closure, but here, the battle is far from over. On one side, we have a frustrated ex-wife, Sarah, saying she's been left financially stranded, no pension payments, unpaid car insurance, and even forced to sell her ex-husband's firearms just to stay afloat.
It hasn't been 5 months. It's now in the third month, I guess, because it was on the 13th, short of the third month. My client has jumped through all the hoops. He submitted the final documentation. He'd be happy to acknowledge that under oath. So that is done by third parties, not by my client. He submitted everything he needed to submit. As far as the current status of the situation, our greatest concern, as highlighted in our motion and our answer, is that there's a car. The car is being driven. It was awarded to the plaintiff. It is being driven by her. If she runs over, God forbid, some person gets into a car accident, gets a ticket, it falls on my client. He is liable for it. No matter what she says, he's going to be held liable because he's still down as the owner of the vehicle. We believe it's appropriate that until such time, if she is ever to get a car loan and ever to take the title out of his name, that the car be parked and that it remain there. So we're suggesting the car be transported to my client's property, what he was awarded during the divorce. It will remain there, will not be driven. And nothing will happen with that vehicle, thereby alleviating the possibility of other lawsuits and other traumatic situations. We believe that's appropriate in the interim until something may or may not happen. In her answer, she indicates she went to Secretary of State and there's a lien. Well, of course there's a lien because there's a car loan on it and she can't transfer it. I don't know if she's ever going to be approved for it. So that's the initial, I think, most urgent request at this point. As far as
the husband's attorney wastes no time turning the spotlight back on Sarah. Notice the strategy. Minimize her pension complaints by blaming the QDRO process.
Further problems for the two of them, that the amount of, I believe it's $714, I put it in my motion, be credited to my client, that he can reduce that from his support obligations that he has been making, and he has done so every month. He made every payment. He's going to be fulfilling his July payment, but that amount be reduced by that $700 figure. He will pay it on their behalf, avoiding a default, and thereby alleviating further problems for the two of them until such time when maybe situation will change. As far as the rifles go, the firearms, the order of this court was very clear. If they are not returned to my client, he is to get credit for them. we added up exactly the amount for the attachment that was provided at the time of trial and as part of the decision of this court. The amount is $6,131.35. We've attached in response to her motion text messages where the plaintiff is gloating. She forged my client's signature on these firearms, on the registration, that these firearms were all sold. Doesn't matter what the purpose is. That's all water under the bridge during the trial. Since they cannot be returned and she cannot apparently pay the amount of money, we believe it's appropriate he should have credit of that amount for the spousal support. So he's not creating more problems for himself. They're never going to be returned to him. He never had an agreement with anyone in the world. The decision of this court is very clear. She's supposed to return them. She's supposed to pay for them. She can't return them since she doesn't have the money.
And listen closely. It's not just one side getting blasted. The judge is crystal clear. Neither of them is following orders. Divorce courts don't babysit adults. Judges don't invent payment plans or solutions.
Plaintiff did make a couple payments on the obligation for the Highlander, avoiding a default. So I'm glad she did that for the prior months, but she has not completed the other tests. My client, on the other hand, has continued the the car insurance. It's paid through October 11th of this year because it was previously paid under a policy. It's a 6-month policy or a year policy as they typically are. So there isn't any continuing payment that needs to be made as far as the car insurance goes. But that's only short term, and that's going to be concluding pretty soon. So of those issues, we believe it's appropriate in the interim at this point in time, because we're not getting cooperation from the plaintiff, that he receive those credits, the credit for the firearm, the credit for the payment that he's going to need to make for student loans, and that the vehicle be parked and remain parked and not to be touched by either party until further of the court, which may or may not ever happen. I'm not sure if the court had any questions of myself.
I don't. Okay. So again, I've reviewed what each party's allegations are. First, I guess I want to say, and Mr. Cutler probably already knows this as an attorney, but for Mr. and Miss Sarah, everybody needs to understand the way that I'm viewing this. The court has an interest in and an obligation to enforce its orders, and so the court's determination is limited to what
His lawyer thought the QDRO defense would buy cover, but the judge isn't having it. Pension divisions don't wait on paperwork. If the judgment says start paying, you start paying. Period. This is a classic divorce battle tactic. Stall, blame red tape. Keep the money flowing into your account.
what punishment or what can the court do to compel compliance. What it's not the court's responsibility or duty to do is to figure out for the parties how they're going to comply with the orders of the court. Mr. and Miss Sarah came to this court. They asked for a forum to resolve their divorce. The court did that according to the law and rendered a decision that in the court's view was as equitable as it could be under all the circumstances. As far as I know, neither party has appealed that decision. So now both parties are stuck with what the court has ordered, and both parties are required to comply with those orders on their own. And again, it's not the court's role or duty or obligation to figure out for the parties or answer their questions or come up with strategies or solutions for them as to how they're going to comply. That is outside the scope of the court's responsibility in this case. And we're not dealing with any legal issues here. We're simply dealing with compliance with orders of the court through the court's opinion and through the judgment of divorce that was entered. As we sit here today, just based on the statements of the parties, I don't think either party has complied with the judgment of divorce. The court's opinion clearly states that Mr. Sarah is required to give or provide half of his pension to Miss Sarah, regardless of whether a quadro has been entered or not, beginning on March 1st. And Mr. Cutler has not.
Did you catch that? He admits his client is only receiving half the pension because Sarah hasn't processed paperwork. Translation: both sides are blaming each other, and both might be right. But here's the danger. When two people point fingers, judges usually don't care.
Half of that money. And in any case, regardless, it was the order of the court that he do that beginning on March 1st, and he hasn't done that, regardless of whether a question entered.
And I apologize, Your Honor. I don't want to interrupt the court, but he is not receiving his full pension. He's only receiving half. Apparently, Ms. Sarah needs to process some papers. So since the order of the court, he has only received half the pension. He'd be happy to acknowledge that on the record. The other half is waiting for Ms. Sarah to fill out whatever form she has to fill out. I'm sorry I overlooked that portion. I'm sorry there's some confusion. I apologize for the interruption, but I want to make it clear. He has only received, since the entry of the opinion of this court, half of his pension.
Okay, well, I don't know whether that's accurate or not. I mean, Mr. Cutler, I accept your representation as what your understanding of it is. I don't know. I don't have any records in front of me that show that. All I know is what the court ordered. And I don't believe that those funds have been received. Mr. Sarah was required to pay the car payment until the judgment of divorce was entered, which was in May. Apparently, he did not make those two car payments. Miss Sarah, pardon me, I'm sorry, I have a cold. Miss Sarah was required under the judgment to either return the weapons to Mr. Sarah or provide him the value that was obtained for those weapons. I found, as a matter of fact, that regardless of whether it was the son that did it or Miss Sarah or a combination of both of them.
This case is a perfect storm of divorce enforcement nightmares. Unpaid pensions, disputed firearms, liability fears over a car, and student loans no one wants to touch. Each issue is small on its own, but
funds to Mr. Sarah or return the weapons to Mr. Sarah. In terms of the student loan debt, again, the parties are required to each pay half of that. It's not my job to decide how each of you are going to meet your obligation. I've simply determined that as a matter of equity, each of you should be required to pay that. And what I'm not going to do, because I can foresee this as being an issue, and I appreciate your suggestions, Mr. Cutler, in terms of crediting Mr. Sarah for amounts that Miss Sarah may or may not owe to him. The problem with that is, how does that get overseen? And how does anybody really know how much Mr. Sarah is withholding and whether he's actually putting those amounts towards the student loans or not? And I am not going to hold a hearing every month and hold the hands of both these individuals every month and make determinations on a monthly basis about who's paying what and how it's being paid. So I'm going to make this really, really simple as we go forward here. And although, again, I don't think it's the court's obligation to come up with a solution, I'm going to provide parties with an avenue for a solution before the court issues any kind of sanctions or coercive contempt actions. I'm going to give the parties 60 days to go to mediation. I'm going to refer this to the mediator, the community mediation. I'm going to, in my referral to community mediation, I'm going to outline the issues and ask the